What would you do if you were injured, racked up tens of thousands of medical bills, and the person who harmed you and their insurance company told you they weren't going to pay them? Not because you didn't need the treatment or because you weren't hurt, but because they felt the bills were too high. This happens more often than you think, especially here in Phoenix. Hi, my name is Heather Cornwell. I'm an attorney here at the Kelly Law Team in Phoenix, Arizona. Today, I want to talk about something that confuses and frustrates a lot of people, including us, when our clients are injured or hurt because of someone else's wrongdoing. And that's this idea that the insurance companies or the person who harmed you gets to avoid responsibility by deciding what they think your medical care and medical bills should be worth. We're going to break down how damages actually work here in Arizona, what insurance companies do to make these lowball offers, and what changes when a law firm is truly prepared to litigate your case. So, what damages are you actually entitled to in Arizona? There's a list of about 6 of them, but when you're injured, one of the primary values to your case and ways to take accountability and responsibility is through your medical expenses. That includes the reasonable and necessary costs of your medical care, the treatment you've received, the services you've been billed for, and really what you need in the future as well. So whether you've had to go to the ER, follow up with your doctors, get imaging, physical therapy, even surgery, those are not arbitrary numbers. They're costs that you owe. And part of the law recognizes that when you're harmed, the person who harms you owes you at least that. But here's where things start to break down. Insurance companies don't want it to be that way. They want to be able to determine what they think medical bills should be. So, in a perfect world, what our system allows for is that when you are harmed and you incur medical bills, those bills should be paid by the person who harms you, fully and fairly. But that's not how it always works. Instead, what we often see are insurance companies that look at those bills and say, we don't think we should have to pay this, it's too much. They argue the treatment was excessive or unnecessary, but a lot of times they just argue it was simply overpriced. Based on that, they make low offers. And I'm not just talking lower than we'd like. Offers that are lower than your actual medical bills, the bills that you have incurred and people are asking you to pay. Sometimes they don't want to cover them at all. Why? Because they're betting on pressure. They're betting that you'll want to move on, that you won't want the stress and the headache of a lawsuit, the time and the ordeal, that maybe even your law firm will encourage you to take a low offer and close out the case because the firm is not equipped to try cases. And unfortunately, that does happen in some situations. But that's not how we approach things at the Kelly Law Team. For example, we had a recent client who was facing tens of thousands of dollars of medical bills related to an incident that was not their fault. The insurance company, the person who harmed them, refused to even pay their medical bills. And like I said, that's just one of a list of damages. And they didn't even want to make them whole by paying their bills. Nevertheless, pain and suffering, future care, lost wages. The insurance company's position was simple. They argued that the medical bills were just what they felt was too high. So we had a choice. Accept that or challenge it. We filed a lawsuit on behalf of our client. And once we did that, the insurance company realized that this case wasn't just going to go away. The conversation changed. Through litigation, we were able to recover more than 3 times what the insurance company said was originally the most they were ever going to pay on the case. Because at the end of the day, it doesn't matter what the insurance company feels. What matters is what was reasonably and necessary incurred by our clients who were harmed, who are the victims, and who is actually responsible for that harm. And if they're not going to accept responsibility, we're going to hold them accountable. So what does it mean when I say that we will litigate the case for our clients? It means we're not just preparing your case to settle. We're preparing it as if it's going to go to court. It means filing a lawsuit when necessary, gathering evidence, taking depositions, working with experts. And most importantly, it means showing the insurance companies that we're not afraid of the process. Because when a firm is willing and able to litigate, the dynamic shifts. The insurance company can't rely on pressure anymore. They can't rely on frustration or fatigue. They can't assume that you'll settle just to avoid a lawsuit. They have to start evaluating the case based on real risks and what they owe. And that's when you start to see more fair outcomes. So why does this matter for you? Now, every case is different. Not every case needs to go to trial. Not every case will even have the same outcome. But the key point is that if the insurance company knows that your attorney or their law firm isn't willing to take the next step, that affects how they value your case from the very beginning. On the other hand, when you have a team that's built to handle litigation, years of trial experience, start to finish, you're in a completely different position. You're not just reacting to their offer. You're in a position to challenge it. Thank you so much for watching. And if you or a loved one needs legal help with a personal injury case involving medical bills or low insurance offers, please call us at 602-283-4122. We're here to help.